Good afternoon, everyone. Thank you all for coming. We're so happy you're all here to hear our lecture today. My name is Shanta Thomas, and I'm the current president of our Women's Law Student Association. I'm honored to welcome you all here to our talk. Here at Vanderbilt, WILSA's mission is to foster a supportive and empowering environment for women and allies in the legal profession. We strive to create spaces where students can engage in critical legal issues, learn from inspiring legal minds, and build strong and supportive communities. The conversation we're having today is incredibly timely and important. In the wake of the Dobbs decision, the legal landscape around reproductive rights and democracy itself is shifting in profound ways, even years after the decision. Discussions like this help us better understand these changes and consider the role of law and policy in shaping our futures. We're so grateful to Kate Shaw for being here today and sharing her insights. And we're so grateful for all of our guests to be here to listen to what we have to say. Before we hear from our wonderful speaker, we have a few words from Professor Rebecca Allensworth.
Hi, I'm Professor Allensworth. I am the Associate Dean for Research, for those of you who don't know me, and I'm here to welcome you to the Florrie Wilkes Sanders lecture. It was established by the family of Sylvia Sanders Kelly, who got her bachelor's degree at Vanderbilt here in 1954, to honor her great-grandfather, that was a Freudian slip, her great-grandfather, Judge John Summerfield Wilkes, and her grandmother, there we go, Florrie Wilkes Sanders, graduated from Vanderbilt University in 1925. Today's lecturer will be Kate Shaw. She's a professor at Penn Carey Law School. She previously was a professor at Cardozo School of Law, where she was also the co-director of the Florsheim Center for Constitutional Democracy. She teaches constitutional law and courses in administrative law and legislation, and a seminar on the Supreme Court. Her academic work focuses on executive power, the law of democracy, the Supreme Court, and reproductive rights and justice. She previously worked at the Obama White House counsel's office and served as a law clerk to U.S. Supreme Court Justice John Paul Stevens and the Honorable Richard Posner of the U.S. Court of Appeals of the Seventh Circuit. Shaw's scholarly work has appeared in the Harvard Law Review, Columbia Law Review, Georgetown Law Review, Cornell Law Review, Michigan Law Review, and Texas Law Review, among other places. And her popular writing has appeared in the New York Times, The Atlantic, Time, The Washington Post, and Slate. You probably know her, though, as the co-host of the Supreme Court podcast, Strict Scrutiny. She's also a contributor with ABC News, a contributing opinion writer with the New York Times, and a public member of the Administrative Conference of the United States. And fun fact, we both were married by Judge Posner. In my case, in his backyard with nobody in attendance. That is a long story that I will tell you if you ask me. Okay, and please join me in welcoming Kate Shaw.
All right, well, thank you so much for that generous introduction. I am delighted to be here. And the talk I'm going to give today is based on a co-authored paper that I have written with Professor Melissa Murray of NYU, also my podcasting co-host. And I know she was here to give a version of this lecture 2 years ago. She had a fantastic time. And so there will be some overlap for those of you who were here 2 years ago, but I know many of you students were not. And it turns out this is an increasingly, in many ways, generative topic, which is the post-Dobbs landscape, the Constitution, democracy. And so this paper is going to focus, or the talk is going to focus, as the paper does, on one of the most important developments, I think, in the post-Dobbs landscape, which is the use of direct democracy, so ballot initiatives, referenda, other type mechanisms, to allow voters to directly register their views on reproductive freedom. So Dobbs versus Jackson Women's Health Organization, I'm sure that folks in this room are well aware, is the 2022 Supreme Court decision overruling Roe versus Wade, Planned Parenthood versus Casey, and deconstitutionalizing the right to abortion, at least as a matter of federal constitutional law. Justice Alito's opinion for the court in Dobbs announced that Roe and Casey had misunderstood the nature of the liberty the Constitution protected. He maintained that a proper understanding of constitutional liberty required an inquiry into history and tradition, and that a Upon conducting that inquiry, it was clear that a right to abortion was not deeply rooted in history and tradition, and thus no right to terminate a pregnancy was a component of the liberty the Constitution protects. But in addition to what he had to say about constitutional interpretation and history, Alito also grounded his decision in claims about democracy, right? Insisting that a basic commitment to democracy demanded the overruling of Roe so that the question of abortion regulation could be returned to the democratic process where it belonged, that is, the people and their elected representatives. So in the wake of Dobbs, the elected representatives of the people got to work, right? In many states, they enacted or began enforcing laws that resulted in dramatic changes to the abortion access landscape in many states, obviously including in Tennessee, severely restricting or banning or nearly outright banning all access to abortion. Other state legislatures passed laws really protecting the right to abortion. But in addition to these moves by elected representatives, the people, without the intermediaries of elected representatives, have also sought to shape the law directly. So voters using direct democracy mechanisms like ballot initiatives and referenda have been going to the ballot box to directly register their views on access to abortion and often other reproductive health care. Where abortion has been on the ballot in states that allow direct democracy, voters have overwhelmingly, although not unanimously, but overwhelmingly voted in favor of reproductive freedom, preserving or expanding abortion access, and voting down efforts to restrict or curtail it. So for people opposed to and galvanized by the court's removal of the abortion right after a half century, direct democracy right now seems full of promise. But as I'm going to describe in this talk, direct democracy has a checkered past, and that past really has to inform any evaluation of direct democracy's current potential. For as much as it has been used to expand and protect rights in the wake of Dobbs, if you kind of widen the historical lens, it's really clear that direct democracy has frequently been used historically to limit or curtail rights. Indeed, over the last 60 years-ish, those seeking to counteract the gains of various civil rights movements have repeatedly and often successfully turned to direct democracy to do that, to essentially resist the gains of those movements, spanning issues ranging from affirmative action to same-sex marriage. So it's important to mine that history to fully appreciate both the promise and the perils of direct democracy in the wake of Dobbs. Now, direct democracy today is not the same as direct democracy in those earlier eras. I think both because the subject matter is fundamentally different, but also because of intervening changes to the strength and resilience of our democratic institutions in recent decades. So the contrast between direct democracy's past and its present, I think, yields important insights about both direct democracy and democracy today more generally. Okay, as importantly, direct democracy's appeal right now as a mechanism for preserving or even expanding reproductive rights speaks directly to a shifting jurisprudential landscape that has rescinded fundamental rights and limited protections for underrepresented groups. So on this account, part of direct democracy's appeal today as a means of securing abortion rights is kind of a direct response to Dobbs in sort of a different way, in that it responds to Dobbs's potential to completely overhaul the constitutional order, both with respect to fundamental rights, which I think has been widely appreciated, but also with respect to our understanding of equal protection, which I think has been underappreciated. So building on some of these insights, which I'll obviously kind of elaborate on, I'm going to suggest that it's important to proceed with caution with regard to direct democracy's deployment to secure reproductive rights. Again, direct democracy, this iteration of it, has come to the fore in a jurisprudential landscape in which the foundations of, again, both fundamental rights and equal protection jurisprudence are being re-examined. And direct democracy's success represents an important countercurrent to those developments. But meaningfully, this dynamic landscape might contain the groundwork for re-examining and maybe rescinding women's status as minorities, at least within the equal protection framework. And direct democracy's success in securing abortion rights may kind of paradoxically hasten that transformation. Okay, so I will develop this claim, but I'm going to start with a brief kind of overview of direct democracy. I will then spend some time developing the history that I just mentioned, and then I will turn more directly to the question of abortion and direct democracy, both its kind of pre-Roe and between Roe and Dobbs history, and then its history or its use, kind of recent history in the wake of Dobbs, and build out some of the larger themes I just mentioned about kind of what this story tells us about Dobbs, democracy, and a shifting jurisprudential landscape. Okay, a little kind of definitional groundwork in terms of the forms of direct democracy. So in about half of states today, voters can directly either circumvent legislatures or actually override legislatures and make law directly. So the first, and in many ways the most direct form of direct democracy, is the initiative power, right? The power to just kind of propose and then with enough support to actually enact directly law. In some states, the initiative power is just the power to enact statutes. In some states, it's just the power to enact constitutional amendments, and in some states, the power encompasses both. Initiatives, can be direct, right? The people just act, legislature has nothing to do with it. But there are also states that have what's known as an indirect initiative process, in which a proposal first goes to the state legislature, and only if the state legislature fails to act can the people themselves vote directly on the proposal. Okay, so that's the initiative. Second big form of direct democracy is the referendum, which is also sometimes referred to as the veto referendum, which is essentially just the inverse of the initiative, right? So the referendum empowers voters to override or veto the legislature. So legislature passes a law, and the people can propose and then actually vote on that measure that the legislature has already enacted, essentially rejecting or vetoing that enacted legislation. And then the third and most common form of direct democracy, which essentially every state except for Delaware has, is the legislatively referred amendment, where voters approve or reject a constitutional amendment that's already been passed by the legislature. So that's not so different from the federal system. Congress passes and the states have to ratify an amendment to the federal constitution. The thresholds are much lower in the states, but the basic mechanism is the same. And again, this is much more indirect than the initiative, in which the sort of process begins with the voters. Okay, so there's a lot of variation in terms of how states have sort of various iterations of these procedures. And the variation extends beyond just the forms of direct democracy, in that states take a lot of different approaches to the role of state officials in essentially serving sort of as a gatekeeping or mediating force between voters and actual enactments. So there are front-end limits on the kinds of measures that can be proposed via direct democracy. Most states have some version of a single subject rule, which says, you can only just put one thing at a time in a particular proposal. There was a recent episode in Florida regarding abortion that was instructive on this score. So there was a proposed constitutional amendment. Opponents in the amendment would have protected abortion rights as a matter of Florida state constitutional law. So actually, let me see what the proposed amendment would have done. It would have permitted abortion up until the point of fetal viability, or where necessary to protect the patient's health. But opponents basically said, well, that's two different things. There's the protection up until the point of viability, and then there's the health protection. And those are different, and so the proposal violates the state's single subject rule. That was unsuccessful. The Florida Supreme Court rejected that argument on the view that viability and patient health are interconnected matters, on the subject of abortion regulation, and thus that was unsuccessful in derailing the effort to get these protections adopted as a matter of Florida constitutional law. So just one example of how that tends to play out. So in addition to these substantive limits on what you can propose in this way, states also impose different kinds of threshold limits for just how much support you have to get something enacted into law. Actually, how much support you have to have first to get something even on the ballot, and then how much support to get something enacted into law. So every state requires the gathering of signatures to demonstrate a degree of popular support for the initiative before it can go before the voters. Sometimes those signature requirements are raw statewide numbers. Sometimes there are specific numbers of signatures from various counties or other subdivisions of states that have to be gathered before an initiative can actually go on the ballot. Also, post-Dobbs, a number of states have sought to ratchet up the signature requirements. In some states that had previously had just a raw number of statewide signatures required, there have been efforts, so far mostly unsuccessful, to change those in order to require geographic distribution of signatures before something can qualify for the ballot. States also impose all kinds of different requirements for filing fees and disclosures that have to be attached to any proposal that hopes to end up on the ballot. Okay, so that's the sort of front end for getting something qualified to even go on the ballot, and then on the back end, states impose different kinds of requirements for how much support is required. Most states just use a simple majority, right? A simple majority, which on some people's view is too low, but a simple majority is all that's required to get an initiative approved and thus enacted into law. Again, can either be as a state statute or as a state constitutional amendment. But there are some states that impose supermajority requirements. Colorado has a 55% threshold. Florida sort of famously has a 60% threshold. So the abortion initiative that I mentioned a couple of minutes ago actually got something in the 57-58% support in this November 2024 election, but because Florida requires a 60% vote in order for an amendment to successfully be adopted by the people, it fell just a couple of points short. Okay, so lots of variety with respect to how you get something on the ballot and then how it actually gets enacted if it is on the ballot. And there's also a lot of variety regarding the role of state agencies, right, like ballot boards and public officials like secretaries of state or attorneys general in the development and approval of ballot language. So, in Ohio, the architects of the 2023 ballot initiative that was ultimately successfully adopted in Ohio initially drafted the amendment, which was a constitutional amendment, in broad terms that would have quote, guaranteed every individual a right to make and carry out one's own reproductive decisions. So sort of by its term intended to cover not just abortion, but also contraception, fertility treatments. The state ballot board in Ohio actually revised a bunch of the ballot language, both kind of limiting the sweep of the substantive coverage, but also replacing fetus with unborn child at a bunch of different places in the amendment, which prompted the initiative sponsors to file a lawsuit challenging the revised language. The Supreme Court of the state of Ohio rejected that challenge, and so the language did go before the voters with that state ballot board set of revisions sort of in place. Ultimately, though, the Ohio initiative did succeed and resulted in amending the Ohio Constitution to kind of provide robust protections for abortion. That is just like a little snapshot overview. There is tons of really interesting sort of granular detail about these variations, but that gives you a general kind of sense of the sort of scope. Okay, so let me also just provide a very abbreviated overview of the history that I alluded to at the outset of direct democracy. Okay, so the United States Constitution very famously makes no explicit provisions for direct democracy. The conventional account is that the framers were deeply skeptical, if not outright hostile to the idea of the people enacting, policy law, constitutional amendments directly. So Madison's Federalist 10 has some kind of famous language dismissing the prospect of direct democratic engagement in governance with essentially just an appeal to the superiority of representative government, explaining that, a lawmaking body of representatives is supposed to, quote, refine and enlarge the public views by passing them through the medium of a chosen body of citizens whose wisdom may best discern the true interests of the country, and whose patriotism and love of justice will be least likely to sacrifice it to temporary or partial consideration. So there's tons of other, kind of rhetoric on that score, but that's representative. Despite all this rhetoric, there actually are glimmers of direct democratic engagement in electoral politics, basically since the colonial period, including sort of the famous New England town meeting, but there's lots of other little examples. But it's really not until the 1890s that direct democracy as a real meaningful vehicle, particularly statewide vehicle for voter-led change, fully emerges. And that's essentially sort of via the labor movement and the progressive era. So in 1898, South Dakota is the first state to adopt statewide direct democracy. A lot of other states follow suit. And the use of direct democracy in this period, so that's the late 19th and the first few decades of the 20th century, really focused on limiting corporate influence on state legislative processes during the Gilded Age, counteracting the power of both big corporations and also state legislatures, and empowering workers and consumers and voters in various ways. So using initiatives, voters in a number of states enacted 8-hour workdays, prohibited child labor, created programs for workers' compensation and pensions, voted to tax railroads and bar them from giving free rides to politicians, pardon me, limited the rates that banks could charge consumers on loans, created commissions to regulate public utilities, railroads, food and drugs, health and safety. So it was a very successful effort in the states that adopted it. And not surprisingly, corporations did not like this. And they sought in various ways to enlist the courts in their efforts to resist direct democracy. They had some modest success in some state courts, but when they invoked the jurisdiction of the federal courts, right, to try to convince the federal courts and ultimately the Supreme Court that direct democracy writ large was unconstitutional, specifically because it was not the Republican form of government guaranteed by the federal Constitution, the Supreme Court basically announced that claims seeking to enforce the Guarantee Clause, which it had previously suggested in another case, but with respect to direct democracy, those claims were non-justiciable political questions, and so the United States Supreme Court was not going to writ large declare impermissible direct democracy, and so that kind of existential challenge to the practice sort of failed in quite clear terms. Okay, so that is, again, a brief sort of snapshot overview of the first era of direct democracy. It sort of draws to a close as the kind of post-war period dawns, interest in direct democracy largely dims, but fast forward to the 1960s, and the successes of various civil rights movements, coupled with increasing diversity and pluralism and secularism, basically spurred renewed interest in using direct democracy for a very different set of goals. So people are obviously familiar with kind of the resistance to the Supreme Court's 1954 decision in Brown versus Board of Education, but I think underappreciated as a mechanism of resistance to Brown was direct democracy. So, in 1956, Arkansas voters pass a referendum directing the state government to pass laws opposing Brown. So ultimately, the Supreme Court affirms Brown and its integration mandate. The federal government deploys federal troops to integrate the Little Rock Central High School. But this 1956 referendum communicated popular hostility to integration and to the burgeoning movement for Black civil rights. So there are other examples of this, but Arkansas is illustrative. But direct democracy does not initially succeed in disrupting Brown and its integration mandate. But by the late 1960s and into the 1970s, as integration kind of gains steam, not just in the education context, but more broadly, voters again turn to direct democracy to register their objections to the pace and to the methods of change. So busing emerges as a key strategy for achieving integration, and in response, voters across the country turn to direct democracy to register and act upon their objections to this method of desegregation. So in 1972, California voters by initiative banned busing. Colorado voters did the same in 1974. Outside of the schools context, in the kind of on the heels of the enactment of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, civil rights activists and advocates sort of train their energy on discrimination in local housing markets, right? And actually, this is before the passage of the Fair Housing Act, but in the sort of 65, 66, 67 period, this is a very serious sort of open housing movement, a serious sort of set of local initiatives, and it's relatively successful. And it sparks a series of direct democracy measures framed as protecting the rights of property owners and landlords. So in 1964, California voters repealed the state's fair housing law that had been enacted by the California legislature by a nearly 2-to-1 ratio. 4 years later, Maryland voters used a referendum to do the same thing, to repeal their statewide fair housing law. And a lot of similar efforts unfolded at the local level, Michigan, among other places. Affirmative action efforts resulted in sort of similar backlash. And critically, the kind of success of direct democracy to counteract many of these civil rights gains provided a potent template for deploying direct democracy to resist other burgeoning civil rights movements, including, kind of importantly, the gay rights movement. So in the 20th and early 21st century, opponents of gay rights leveraged direct democracy with dozens of anti-gay rights initiatives and referenda that were aimed in various ways at limiting or restricting gay rights. So these efforts prevail in a number of places, and they take a lot of different forms. Sort of the two kind of big categories I would put them in are: one, essentially attacks on laws that protected against sexual orientation discrimination, and then two, bans on same-sex marriage. And during this period, in a move that actually does have some of its roots in the kind of progressive era legislation, in addition to all of the sort of, worker protective legislation, there was a sort of a darker underbelly to some of the early progressive era uses of direct democracy, in that some of it seemed animated by anti-immigration or xenophobic sorts of impulses. And so you sort of see these kind of proliferate at the same time as some of the anti-gay rights initiatives. So you have direct democracy measures doing things like imposing English-only mandates and denying various kinds of social services to undocumented immigrants. So all of this, right, this kind of second epoch or second era of direct democracy led a lot of scholars in the 1970s and 1980s to raise very serious concerns about direct democracy, right? So echoing in some ways many of the framers' concerns that I alluded to, which is just that direct democracy, which kind of by design allows for unchecked or kind of minimally checked expressions of majority will, kind of posed a grave threat to numerical minorities, and that it was sort of a fundamentally kind of rights, or at least the rights held by sort of minority groups, denying kind of measure. And those arguments end up, getting used. So there's scholarly arguments and then arguments that end up, giving rise to various kinds of legal challenges to some of these measures, which did yield some litigation successes. So cases like Reitman versus Mulkey and Hunter versus Erickson, or on the gay rights side, Romer versus Evans, which some people have probably read, did lead the court to invalidate the output of direct democracy on kind of equal protection grounds in a number of cases. But that's a small subset of, kind of the measures that were broadly adopted in this period. Okay, so that's a lot of background. So let me turn now to the kind of main topic of abortion and direct democracy. So over the past half century, when direct democracy measures end up being used quite successfully to counter various kinds of civil rights gains, they're actually far less successful when it comes to abortion, and that's actually either in advancing or curtailing reproductive rights. So as early as the 1970s and before Roe versus Wade, abortion was the subject of lots of proposed ballot measures, so including both efforts to enshrine abortion rights in state constitutions, but also measures aimed at either restricting access to abortion or securing fetal personhood as a matter of state constitutional law, and then kind of various measures about parental consent and prohibitions on government funding for abortion and things like that. So in 1970, so 3 years before Roe gets decided, Washington state voters approved a referendum that was the first pro-abortion measure to appear on a state ballot, and the referendum succeeds and actually enshrines protections for abortion as a matter of Washington state constitutional law. But that referendum didn't really translate to other success in other states. So you had, measures in 1971 and 1972, just kind of in the run-up to Roe, proposed but unsuccessful in securing kind of analogous protections under other state constitutions. So then in the 1980s, as opposition to Roe and opposition to abortion intensified, abortion opponents also tried to use direct democracy to limit abortion access, right, within the framework set forth in Roe, or some within the framework and some kind of posing direct challenges to the framework. And there were mixed results to those. So voters in Colorado and Michigan and Arkansas narrowly, but did approve measures to prohibit the use of state funds for abortions, although similar measures failed in Oregon and in Alaska and Washington and Rhode Island and Massachusetts. But a couple of decades later, really beginning in the 2010s, a lot of those measures end up getting more success. So in 2014, right, 53% of Tennessee voters approved language that explicitly disclaimed any state-level constitutional protections for a right to abortion. Alabama voters followed suit in 2018. But critically, in those years, the 2000s, the 2010s, these more ambitious anti-abortion measures were largely unsuccessful when kind of channeled through the measures or the mechanisms of direct democracy. So there were 4 fetal personhood measures that would have defined person to include, quote, any human being from the moment of fertilization, failed in Colorado multiple times, actually, and in Mississippi as well. In 2006 and 2008, South Dakota rejected 2 different referenda that would have prohibited all abortions except for those medically necessary to save the life of the pregnant patient. Now, Roe is the law of the land, so unclear exactly how much to read into these, but even as sort of expressive enactments, they were unsuccessful, even in potentially surprising states. Okay, so I am trimming a lot of this history, but then we get to 2022, and of course, Dobbs is decided. And even before the court announces its decision in Dobbs, activists were well on their way, in part because of the kind of tenor of the oral argument in Dobbs. The writing was sort of on the wall. And then obviously when the draft opinion leaked in May of that year, it was quite clear, right, that Roe was going to be overturned. And so Voters in California and Michigan and Vermont began mobilizing to actually put measures on the ballot to protect reproductive freedom. And the June 2022 decision really kind of catalyzed further interest in other states. So in August of 2022, there was a special election in Kansas that featured a ballot measure aimed at stripping protections for abortion from the state's constitution, where the Supreme Court of Kansas had previously, found those abortion protections to exist. And in the wake of Dobbs, Kansas voters flooded the polls in this off-cycle election, defeating this measure, again, to strip protections from the state constitution by a very wide margin. Then in the November 2022 midterm elections, voters in California and Michigan and Vermont did actually enact into law those proposals that I mentioned a minute ago. And in the same midterm cycle, direct democracy ends up being deployed to essentially resist the drive towards greater restrictions on abortion. So in Kentucky, as in Kansas, voters essentially distanced themselves from Dobbs by rejecting an initiative that would have extinguished abortion rights under the state constitution. Then in 2023, another off-cycle election in Ohio, which I mentioned a couple of minutes ago, featured 57% of Ohio voters voting to amend the state's constitution to protect abortion rights, even with the modified language that I mentioned, and also sort of even in the face of pretty kind of dramatic efforts by state officials to manipulate the timing of the vote and also the threshold of success for actually adding the abortion protection to the Ohio Constitution. And then most recently in November 2024, so even as voters obviously returned Donald Trump to the presidency, voters in 10 states cast their votes on various abortion-related measures, with abortion prevailing in 7 of the 10, and a majority of voters supporting abortion protections in 8 of the 10, because Florida, as I mentioned before, a majority, but not a sufficient supermajority of voters wanted to adopt the abortion protections. Of the 7, though, one sort of really striking result was that in deep red Missouri, voters, not by an overwhelming margin, but by a majority, vote, in addition to returning Donald Trump to the White House, to actually enshrine robust abortion protections in the Missouri Constitution. Okay, so in the final moments, let me say a few words about, I think, what we should make of the increasing appeal of direct democracy in view of a changing electoral landscape and shifting judicial norms that may render democratic engagement in this way both more attractive and more urgent, and that also supply reasons for caution in embracing it. Look, history makes clear that direct democracy is always responsive to developments in representative government and electoral politics, and that's the case here. But I think direct democracy is responding to a different set of developments than direct democracy sort of previous eras. And part of the kind of democratic landscape that direct democracy is responding to right now is one that is riddled with distortions that I think make it more difficult than if kind of in eras past for the ordinary voter, I would say, to see her interests reflected in policymaking. So Professor Murray and I have argued this at length elsewhere, so I'm not going to rehash all of it now, but the democratic landscape today, largely as a result of a number of interventions by this Supreme Court, is likely to be profoundly unresponsive, right, to the aggregate desires of the population. So extreme partisan gerrymandering, blessed by the Supreme Court, I think, essentially in Rucho, the underprotecting of the voting rights of various minority groups, a non-intervention posture with respect to state efforts to disenfranchise or restrict access to voting, the active disabling of the ability of government to restrict the impact of money on electoral politics. All of that, I think, is both traceable to the Supreme Court and responsible for, I think, quite distorted outcomes in terms of legislative democracy that kind of make traditional representative government far less responsive to the voice of the people today than, the sort of abstract conception kind of channeled in that James Madison quote that I talked about, or even in the kind of comparative claims that critics of direct democracy writing in the 1970s and the 1980s sort of assumed about the way representative democracy was going to work and why it had comparative advantages, right, as compared to direct democracy. And so we think that kind of changed electoral landscape helps explain, both the interest in and the results of direct democracy. So that's, I think, not like a sort of wild or kind of novel claim. But I think Dobbs also has reshaped the jurisprudential landscape in, obvious ways with respect to fundamental rights, right? So Dobbs really announces a new test when it comes to the identification and protection of fundamental rights as a matter of the federal Constitution. But again, I think it is less appreciated what Dobbs might mean in the context of constitutional equality. So Alito in Dobbs is deeply dismissive of the argument that the Equal Protection Clause might serve as a doctrinal home for the abortion right. He just describes the argument as, quote, squarely foreclosed by our precedents, and references the 1974 pregnancy discrimination case, Geduldig. So, right, there's a lot to say about that, right? The Dobbs majority's kind of elision of later cases like VMI and Hibbs that take a far more expansive view of constitutional sex equality goes, I think, beyond the obvious neglect of both those cases and the kind of imbrication of kind of liberty and equality and privacy that at least Casey, is sort of undergirded by. But it also, I think, may suggest a revisiting of the constitutional settlement that suggests that sex equality under the 14th Amendment is cognizable, that mandates a degree of heightened constitutional scrutiny for laws that distinguish on the basis of sex. Like, I think all that might be lurking in the very brief discussion of Geduldig and of sex equality. So, the opinion has this off-cited observation that, quote, women are not without electoral or political power, but that may do more than just justify the decision to, retract the right announced in Roe and remand the abortion kind of right to the democratic process. It may also be the kind of harbinger of a changed sort of equal protection landscape and constitutional order. So as Professor Murray and I have argued elsewhere, Alito's equation of women's political power with just kind of their numerosity among registered voters neglects the many, many ways that the legacy of women's disenfranchisement and subordination continues to shape their participation in public life. But despite its sort of, we think, facile account of political power, the observation that Alito makes is kind of worth parsing, that not without electoral and political power, as is the subsequent observation that, quote, the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. So maybe those aren't really just asides, right? Maybe this invocation of women's political power actually means to gesture toward the entire structure of equal protection theory and practice, and invites a reappraisal of women's status within it, right? So since the late 1970s, this kind of basic kind of equal protection kind of doctrine, women have been denominated some kind of a, probably quasi-suspect, but some kind of a suspect class. But in certain respects, women have always been kind of an odd fit with the equal protection calculus because they're not a numerical minority, right? Indeed, they are a majority of the population. Now, despite their numerosity, they have suffered a history of discrimination because of disenfranchisement and social role expectations. They have lacked political power and capital. But this emphasis on numerosity and political power, right, equating political power with voting, may just be the first step toward overhauling the entire equal protection framework and essentially affording sex discrimination the same treatment that Alito, I think, gratuitously announces will attach to scrutiny, like federal constitutional scrutiny of restrictions on abortion, which is highly deferential, rational basis review. So we think that it might all be lurking in the opinion in Dobbs. And we think that this observation at least opens up the possibility that the very success of direct democracy may provide fodder for hastening this constitutional change. Now, to be clear, I don't think that's a reason for abandoning direct democracy. In a post-Dobbs world, state constitutional protections may be the most enduring way to secure reproductive freedom. I don't think the use of direct democracy here implicates the same dangers for minority interests as its use during the kind of civil rights backlash era. And it is also happening against a landscape in which representative democracy is profoundly distorted and unlikely in many instances to produce broadly wanted outcomes, and in which courts have retreated, including, but not only in Dobbs itself, from providing robust protection for rights. So, direct democracy, I think, always has to be assessed sort of with the in comparison to what question in mind. And the electoral landscape has changed so profoundly that I think does have to affect our assessment of both the promise and the limitations of Dobbs. So I do think it's critical to work toward, right now, expanding access to direct democracy, to improving the conditions in which it is used, shoring up the guardrails that prevent state officials from thwarting the meaningful use of direct democracy. But alongside its promise, I do think it's considerable peril. So I think it's important to kind of assess direct democracy in this new post-Dobbs era with eyes wide open. Okay, went long, but not too long. So thank you so much for your attention, and I'm happy to take a few questions.
Thank you.
Thanks. Okay, thank you.
Okay, who's got a question for Professor Shaw?
Thank you so sorry. Thank you so much. So I'm from North Carolina, which notoriously has like confusing amendments on the ballot and things like that. So when you were talking about the language stuff, that was really interesting. I know this is going to be state by state, but do you have kind of ways that voters can like regulate the way that election officials are able to word things, or just that's an issue that occurs a lot in where I'm from, and I'm just curious your thoughts on that.
Yeah, I mean, I think you're right that like at a brass tacks level, that is so important, right? So I guess I think that kind of light touch. I mean, I think that the less kind of meddling and sort of intermediary kind of empowerment that a state system involves, the better. So I do think that allowing those who can amass enough support to get an initiative on the ballot should be the kind of drivers of the language. But I also think sort of from the perspective of voter confusion, you know, word limits and simplifying sort of, which is a little subjective or maybe hard to enforce, but that those are kind of overarching kind of guidelines that should inform sort of what ends up on the ballot. But I definitely think that the kind of intervention that we saw in Ohio, which clearly does put a thumb on the scale in terms of the language choices that get made, is something that if we're thinking about, you know, kind of designing institutions to do a better job channeling popular will, disallowing or really limiting the ability of state officials to intervene is really important. And I think you're right, there are hard questions about the ballot language is one thing, but what about, you know, kind of supplementary materials that can inform the casting of the vote? And I didn't talk about this in the talk, but there's just like a ton of different, you know, states have lots of different guidelines. Some of them actually produce official pamphlets that, you know, I think are probably questionable, but are often like helpful guides for voters. So I'll say that in the paper, we do some significantly more than I did in the talk, although I think there's a lot more to be done that is on this kind of the details of implementation. But I do think that simplifying language, limiting the ability for kind of these intermediaries to control language are sort of two benchmarks, but I think there's a lot more sort of specific design kind of debate and kind of deliberation that's important. So thank you.
Okay, another question. How about this gentleman right here?
I was wondering, I'm thinking about Melissa's paper on jurisprudence of masculinity and her Duke paper on remedy, and how you sort of tie in this, you know, the court's like, we need to protect white males, you know, thing that's coming out. I mean, even in Rahimi, right, a case that's about domestic abuse, there's essentially no discussion about women at all, right? And so being a pessimist, right, I sort of read into almost a, you know, undercurrent of, yes, this person's bad, right, this guy, but we want to protect against all of these future issues, right, these future he said, she said, that Alito brings up, you know, during Rahimi's oral argument. And so I just wonder how you sort of see that fitting in.
So I love you're clearly Melissa Murray completist in terms of the literature. Yeah, and I think it's right that she is developing in a body of papers and a book that she's working on now, this, you know, set of arguments about the kind of new equal protection framework. And it is one in which sort of protecting men and white men, maybe in particular, as, you know, the actual sort of not numerical minority, but a group in need of sort of special protections under the Constitution. I'm not, in terms of, I'm going to put Rahimi aside because I'm going to think about that a little bit. But I mean, this is only somewhat responsive, but I think I wanted to say something about it. So I think if it's okay, I'll use this as an invitation to do that. I mean, I do think it's possible that the court may be seeking to lay the groundwork for actually announcing that yes, women are not in need of protection in this sort of kind of newly reconfigured equal protection landscape, but there is an entity in need of special protection, and that entity is the fetus, right? So I think that is a genuine possibility. John Hart Ely, you know, in a famous piece just post Roe, really, really critiquing Roe, Wages of Crying Wolf, has a sentence in which he basically says, well, if I was giving my common law students a test and I asked them as between women and the fetus, who is, you know, a minority more in need of protection, yeah, it's true. This is 1973 or maybe early 74. It's true there are not that many women in legislatures, but there are no fetuses in legislature, so they are less likely to be protected through the majoritarian process than even women. So now I think that it is difficult to, as a matter of kind of the liberty discussion in Dobbs, to see this court, following up on Dobbs with an opinion that announces as a matter of liberty, that there's a right to protection that is a matter of kind of the liberty protected by our history and traditions. Because even if I think Alito, I think, very much misrepresents much of the history in Dobbs, I think it'd be very hard even for him to suggest that there is a robust history and tradition of the protection of fetal life in the context of the way we have regulated abortion, even if there's lots of kind of conflicting strains and ways you can spin different kinds of accounts. But maybe it's an easier argument to make in the context of equal protection, that you're not quite as tied to history and tradition, and really kind of, these sort of traditional indicia of protected status under equal protection, can appear to be satisfied if we're talking about protecting the fetus. So I think that is related to, not exactly the same thing as the argument Melissa is developing, but we certainly think that is a possibility, that, we don't make a strong version of the claim that is definitely something that Dobbs is sort of intentionally laying the kind of groundwork for, but I think it's absolutely a possibility. Thanks.
Thank you for coming. I really enjoy listening to the podcast on the way in, so
thanks.
that's fun.
Thank you.
I'm
not edited by a really good editor here, so that was like a little more like umming, but yeah, go on, sorry.
I did have a question. It's more about the protected class, that sex as a protected class.
Yeah.
How do you think the ERA kind of affects that? Like, if something affects only one sex, does that maybe give it the protected status that the Supreme Court might look at in the future?
Well, so if you're saying if the ERA were actually, I mean,
kind of, because it got ratified, but there's question about the timing. Yeah.
Right. Yeah. So essentially, right, there is there is a sort of the kind of an epistemic question, like, what is the status of the ERA? Is it in fact already the 28th Amendment, in that it has satisfied the requirements the Constitution sets forth for actually amending the Constitution? Obviously, as one of his last acts on his way out of office, former President Joe Biden announced, I actually now think that despite the fact that the kind of window for ratification had closed before the final 3 ratifications, and despite the fact that a couple of states have sought to rescind their ratifications, the number is, there were the 38 ratifications, and so it is now the 28th Amendment. I think if that were true, like again, it might be. I think there's a good argument that it is. The question is who is going to be the kind of ultimate sort of decider there. And interestingly and correctly, I think historically, the Supreme Court actually hasn't announced that, and this is a Supreme Court that loves to say it's the final decider of all questions, and so maybe this Supreme Court would say that about this too. But historically, at least, the Supreme Court has said actually it's really Congress, not the president, but Congress who decides if an amendment has been properly ratified. And I think if we got a Congress that actually said we do have a 28th Amendment, ultimately, I mean, if I'm being realistic, the Supreme Court would decide if that was correct or not. But I think if this ERA with the language that the ERA that has been passed and ratified maybe contains, would contain robust sex equality guarantees and sex discrimination prohibitions in ways that I think would kind of upend everything that Dobbs says about sex equality. I mean, that's not to say that the court couldn't take a run at trying to make the same set of arguments about the kind of irrelevance of sex equality guarantees to the abortion question or abortion restrictions. But I do think the court would have to kind of start from a blank slate in assessing the question of whether abortion restrictions violate equality guarantees if there are explicit ones of the sort the ERA contains. So thank you.
Just one way in the back, yes.
Okay, so kind of in regards to what had just been asked a little minute ago about the equal protection for the embryo. So the House recently just introduced a new bill, which is going to essentially grant equal protection to a fetus and an embryo under the 14th Amendment. How does something like that sort of impact direct democracy and all these really important decisions that you were just talking about, and kind of set us on the pathway to a national abortion ban?
Yeah. So, yeah, I mean, I think that, look, if Congress actually, of course, like we still have a filibuster with respect to legislation. So there's, at the moment at least, there isn't a realistic possibility that a bill like that, even if it passes the House, and obviously there's a Republican-controlled Senate, but not 60 votes in the Senate. So even if the president and the House were on board with something like this, we don't have the votes in the Senate to do it right now. But obviously, you can imagine a world in which you do have those votes. I think it is more likely that we would have an incremental federal legislative effort that would severely restrict something like a 16 or a 12-week abortion ban. You could imagine, some not too distant future Congress actually enacting, and yeah, that limits the ability of states, because even though it seems kind of weird if it's a federal statute, does that really supersede a state constitutional provision? But federal supremacy principles have always been understood. If it's federal law, whether it's a federal statute or a federal constitutional guarantee, that is supreme. And so the state law to the contrary. I mean, I guess if it's a ban, like if it's an actual federal ban, like at the 16-week or 14-week or 12-week or whatever mark. So there are limits, absolutely. So in the absence of something at the federal level that is going to, restrict in an affirmative way the ability to perform abortions, I think that, there is reason to be really, interested in and focused on state-level democracy, but in states that don't have access to direct democracy, that is only going to get us so far. And I think it's true that part of the reason it can't be a complete answer is because it is only viable in the kind of absence of decisive federal regulation. And I should say there's lots of things the federal government can do, and I think in the pretty near term will do, short of actually passing one of these bans, whether that's trying to enforce the Comstock Act to restrict the mailing of both abortion medication, but also maybe surgical implements used in abortions and things like that, and enforcing an interpretation of the federal statute that guarantees that federally funded hospitals provide some emergency care to pregnant patients in severe kind of crisis. So there's lots that can happen short of passing a federal statute. Yeah.
I have a question, actually.
Yeah.
Okay, so I'm going back to my 1L con law class here and asking this question. But you spoke as if it were true that women had equal access to the democratic process, that would totally undo a justification for keeping them on the list of suspect classes. Mm-hmm. And I wouldn't have thought, I guess that's Caroline Products. This is where I'm like, oh, what am I saying the right thing? Has the ship totally sailed that we can't say that you have suspect classes if you don't have a good reason other than animus to single out a certain? So, for example, I wouldn't have thought that the reason why we have race, the ultimate sort of suspect class, is only because of access to the democratic process. I thought it would also be because if you're making a law that singles out or specifically disadvantages a race, that is just itself unlawful.
So yeah, I think that's so maybe I'll say two things. One, no, absolutely right. So we have Caroline Products, and then we also have just, and John Hart Ely, who in his, wearing his, a different hat actually sort of helps kind of develop some of what is in the footnote 4 of Caroline Products. But in general, one, but not by any means the only kind of factor in deciding whether a group actually is entitled to this kind of, class status that would require some heightened constitutional scrutiny of laws that burden them. Political powerlessness is a big one. Numerical minority, a history of discrimination, the kind of irrelevance of the particular trait to the ability to contribute in a productive way to society. So these are things that the courts and the executive branch, like the government in general, has identified as factors. And so certainly the kind of numerical majority was already not a feature that sort of argued in favor of inclusion of women. So I think our point is just that if you also can make the claim, which I think is a deeply dubious claim, but if you can make the claim that also political powerlessness is gone, and yes, you have some history of discrimination, but it's more and more distant, is that enough to actually support continuing status as a protected class? And I think at least the claim can be made that it's a much harder argument today if women are flexing their sort of political participation muscles. Not that it should be, but that I think there's a claim that it is. And yeah, I actually think it's right that, the sort of anti-animus strain of equal protection jurisprudence wouldn't necessarily be impacted here. But I don't think it's been used if there's been any lower court cases that have specifically focused on animus in the context of sex discrimination. I'm not thinking of one, maybe my lower court cases, but obviously that's an important strain. But I think, again, they're politically powerful now, and they're a majority of the population, I think, would just undermine a court's sort of serious embrace of kind of animus doctrine, which, kind of fundamentally is about a majority singling out, right, for, kind of irrational reasons sort of grounded in dislike or, bias, a group. It's hard to see that being applied with respect to a numerical majority for me.
Okay, I think we have time for one more, and that's going to be the young lady in the green shirt.
Thank you again, Professor Shaw. This is sort of off the direct democracy question, but I've been thinking a lot about sort of extraterritorial application of state anti-abortion law. What do you see as sort of like the big constitutional questions there for wanting to sort of regulate abortions that happen outside of state borders? And do you think that sort of undermines the direct democracy gains that have been made by pro-abortion states?
Yeah. It's a great question. There's a lot to say about it. I mean, one is there is this sort of casual aside that Justice Kavanaugh has in his concurring opinion in Dobbs that suggests that the, atextual, but, maybe he thinks real, and I think so too, right to travel would, be sort of a powerful tool for resisting efforts by states to, undermine their ability, the citizens' ability to leave to secure abortion access elsewhere. So, it's the fifth vote for Dobbs, even though, Roberts also would have allowed the Mississippi ban to stand without, or the Mississippi restriction to stand without overruling Roe. So it's a somewhat complicated math in terms of figuring out how much stock to put in that Kavanaugh concurrence. But I think that's one kind of the right to travel, like, is one big post-Dobbs question about sort of, kind of interstate relations. But there's also these very complex, and I'm by no means an expert, but kind of, choice of law and maybe federal common law, to the extent federal courts are going to be asked to adjudicate these questions with respect to, both the criminal indictment in Louisiana of this New York doctor and New York's passage of a shield law that by its terms, right, announces its, unwillingness to cooperate in the interstate extradition of this doctor who has been, again, indicted for sending abortion pills into Louisiana. So these kind of both aggressive efforts to export restrictive abortion policies by a state like Louisiana, and also the frankly aggressive efforts to protect citizens in the state of my home state of New York, I think will probably result in clashes that, again, sort of have these tough choice of law, and maybe, again, federal common law seems weird, but I think that's going to be a place that, unless and until Congress tries to do something to provide, to mediate in some ways these kind of interstate disputes, as it tried in different ways with respect to marriage, both DOMA and then the Respect for Marriage Act, which point in very different directions about a related landscape with respect to kind of state laws reflecting very different policies, pre-Obergefell with respect to same-sex marriage. So I think that it's, the possibility of like a total breakdown of kind of interstate relations that have sort of held in shaky but relatively durable ways basically throughout our history is like a very real possibility. And it's one of the things that makes me the most nervous about the sort of post-Dobbs landscape, but the list is long. So thank you. Yeah. Please join me in thanking Kate. Thank you.